lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. Karen Rea and Judge Cosgrove, Special Prosecutor Cosgrove, because of that, I have, from the beginning, kept a very line of separation between both Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I know is that there are 2 phones that were searched by Pretrial and is in the possession of the District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that but relationship and where information, some of the suggestive grand jury minutes, was passed per Carney. Originally, a third party was used, an intermediary, where
appeared in the public record?
I don't know that. I know that the attorneys are very well aware.
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I would re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports been requested, been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. As it relates to consciousness of...
As Your Honor is aware, consciousness of guilt is a different standard. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly and directly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was witnesses. In the search warrant itself, there's extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. Don't the communications sought or the data related there?
I'm not clear on your question, Your Honor.
Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the Addendum A to Trooper Tully's affidavit in support of the search warrant. Calendars, alerts, reminders, notes, text messages, videos from April 1st, 2023 through and including October. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Carney, so
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Counsel, can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of the Court. We didn't see which case number was called for this Rule 17, if it was Mr. Carney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue is going to be dealing with is on Ms. Reed's case number as it pertains to her rights and the
This
issue.
meeting is being recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular.
The case number that was called was the Commonwealth versus Karen Rea.
00117.
Okay.
That's correct.
And she needed to be here. Going forward, in terms of her case, I mean, this is her case.
You have to challenge a Rule 17 request to documents produced in another case.
Because it specifically pertains to the prosecutor asking for information.
Those are evidentiary issues, counsel,
Correct, but we...
which can later time. Those are what you're suggesting are evident. For Mr. Kearney's case, the evidentiary issue will be dealt with at a later time.
I
This is
understand, Your Honor, and respectfully, I don't necessarily be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth has, there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. Rule 17s dealing with third-party information, cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number, and the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
counsel. This motion's been pending for a week and a half now.
Correct.
I don't have opposition from you. I don't have any submission from you.
We intended to submit oral argument as it is to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Cannoni,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the various issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current?
I will step back. I will be a little mouse in the room. I just need to be. Mr. Bradle is finished. I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my filing. That's an issue in terms of a filing. So just put it
Thank
down.
you. Thank you,
Well,
Attorney
Your
Brennan.
Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion to rule. Not a party on the Rule 17.
Thank you, ADA Brennan. She's case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her ADA Brennan, with the court's apologies for the interruptions. The crux of the issue, I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant. Materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree. Far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at in the murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, including but not limited, would suggest Karen Rea case. B is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence. E and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories, because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is
categories include from Mr. Kearney with counsel from Ms. Reed.
no, I think those would be privileged. Secondly, there are most filed in this case, not Karen Rea case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Prosecutor Cosgrove. And in that motion, that the two phones that I'm seeking information from have already. And he also notes in the motion that there does not appear to be any attorney-client Commonwealth's revised proposal for examination of digital material seized. That's relative to the four phones that I'm not seeking. However, it's instructive because in that motion as well it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the two phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable, the consequence of Mr. Kearney's actions. She helped fuel this information and identifying the witnesses in her case. Or is interested because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court. I
don't think that's necessary, so I'll decline respectfully the offer. ADA Brown, thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of its consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, will dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of this warrant, by Ms. Reed to the relationship. And so I ask you
Thank you very much, Your Honor. Good morning, Your Honor, counsel.
Good morning.
Judge, this is a Lampron request, is the case, and I the focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour. I happened to look at the Reed docket last night. It's how many motions in limine are filed. You know, the government's trying to try that case through motions in limine versus, you know, the immediacy of a trial. It was my impression of that. So, you know, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, you know, there's relevancy, evidentiary, meaning there has to be evidence. Not otherwise obtainable. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, oh, well, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me, counsel.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of, not even so much representing Mr. Kearney, but just as a constitutionalist, as a person interested in the Constitution as an attorney, I saw this, I read the search warrant, you know, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about in there, right. find and isolate communications. Wants to criminalize communications. And if you look at my press, read a few things from it. You know, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is understanding, and everyone's here and in their case in chief relative to this issue about communicating with Mr. Carney and consciousness of guilt, unless it was quote unquote case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California, we talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off us and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss
Sure.
in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17?
All of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them. They're all protected by the... Let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation. And it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. Nexus between the phone and the crime, and talked about quotes, Your Honor. The cell phone inventory of just about everything that is materially important to messages, emails, notes, thoughts, communication, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
Well, Judge, it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people. I am here, and the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife communications.
Not asking.
For husband-wife communications, we're asking for that journalist source material. There's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny, Judge, just about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, 88 Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Lee, Your Honor.
Thank you, Your Honor. Elizabeth Little appearing on behalf of Ms. Reed. First, I just want to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradel's request in opposition to this rule. Attorney Bradel. Apologies, Your Honor. There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. And so just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. EDA Brennan, I'll hear from you in response briefly.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of a commission of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt?
Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
That is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witness unless the door if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The something that reflects her consciousness of guilt for the crimes that she's alleged to have committed. We know she was providing information, even protected information, to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Rea trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible.